going to kind of hit the high points on for your legislative summary. Excuse me. Any of these bills, I put a lot of words on the slides themselves. I'm certainly not going to read those to you, but that kind of gives you a synopsis of what happened. Some of you probably don't care, and I understand, but if you hear about them, at least you'll know, well, I think they did that this year. So at least you'll have some idea or a flavor of what happened on some of these bills. The RICO Act, which is racketeering, was passed. This is something that they had been trying to do for about 3 years, the AG's office and the District Attorneys, County Attorneys Association. Part of the problem was it was so broad, and they've narrowed it down to actually 3 categories of people. This is going to be conduct of folks that are these covered people in the middle of the slide. And that's essentially gang members, those involved in human trafficking, and then those involved in manufacturing and cultivating controlled substances. And so, again, a fairly extensive bill. A lot of definitions in this because they wanted to narrow the focus on who actually applies to this particular bill. But it comes with a steep penalty, so you're looking at kingpin type of folks at a level 2 person felony, and they even have specific bond requirements as well on it. This was Senate Bill 58, what we were looking at before on the Special Rule 12. And this just goes through, I tried to do a clarification. They were trying to do a clarification of when it actually applies. And as I said, these 4 points that are underneath here, I tried to encapsulate that in the table, but it would be only for your manufacturer when you've got a meth situation. This isn't too awfully as important as some of the other ones. This is just for those of you that do forfeiture actions and those type of things. The Attorney General's office now has jurisdiction to bring those in Shawnee County. If it's a multiple county type situation, venue also is proper in Shawnee County as well. The human trafficking is what we talked about. It was one of the other big 3. And again, we've got a lot of commercial sexual exploitation was newly created. And you can see what the penalties, it's a level 5 person, unless it's the victim's under 14, and then it's off grid. But they've changed prostitution to selling sexual relations, and all the rest of these, prostitute to person selling sexual relations who is 18 years of age or older. Promoting prostitution has become promoting the sale of sexual relations. And again, the elements have stayed the same. The only thing that's changed is most of the levels have been elevated, some from misdemeanors to felonies. So keep those in mind if you happen to have those. Patronizing a prostitute has been changed to that buying sexual relations that was in the journal entry, and it used to be the C misdemeanor, and now it's an A person, unless you've got a prior. I'm going to skip through some of these. For your municipal courts, the judges, their duty now has been expanded. They used to only have to do Class A and B misdemeanors. Now they're having to report basically everything that are comparable to convictions on the state side or county side. And part of that is that they've already had to do that with the DUIs as far as the DUI repository as well. Those of you that were concerned with boating under the influence, it also is brought up to levels of regular DUI starting in January. It's an interesting one. House Bill 2044 gives you there was some concern as to what do we do with the dealers if they're out there hurting our kids, and what kind of punishment can we levy even more than what we already do. This provides 2 new crimes. If great bodily harm is caused in the distribution of the controlled substance, it's now a 5-person felony. If that situation causes death, it's a level 1 person. So, HB 2093 has a myriad of things from DNA testing to white-collar crime. It also includes the felony murder, which now the law specifically says that felony murder can't have any lesser included offenses, and it is an alternative to first-degree murder. HB 2169 was another piece of legislation that was forwarded by the Commission. And in this particular one, it's essentially a Disposition of Detainers Act. We were hearing things from the judiciary that they were wanting to take care of those probation violations that were occurring, and this actually only applies to when the offenders are incarcerated in DOC. So it's kind of like it's in the Disposition of Detainers Act, and all we did was add probation violations to that act. So in essence, what happens if you have an offender that's incarcerated, DOC was struggling with the fact that you had offenders that were preparing them for reentry, getting them ready to get out, and as soon as they get ready to do that a month ahead of time, they get smacked with the PV. And the judges were frustrated on that too, because they'd have it hanging out there and then they'd have this set up. So this it still requires the offender it is affirmatively on the offender to actually make that request. So they have to make the request within 180 days. It has to be taken up or it's dismissed. This was an issue that apparently there was a lot of incidences down in Wichita area, and so some of the folks down there were forwarding this. It is apparently a Middle Eastern custom that is very painful, very horrendous, and leaves scarring and those type of things. The legislature has now criminalized this type of activity. HB 2218 is your DUI. Got to have a bill every year on DUI. But this particular one is a little less than some of the other ones that have been before. From an evidentiary standpoint, the officer now can actually arrest an individual, take them into custody for something other than DUI, and then be able to perform the test, whereas previously they weren't able to do that. Now that it provides now for any violation of state statute, then they can actually, county resolution and city ordinance too, they can do testing. Another big thing is that there was issues as to, case law essentially said you could not prove aggravated battery reckless by virtue of just DUI itself. That in and of itself could not be actionable. And so there is now a provision in the aggravated battery statute that specifically speaks to DUI where it didn't before. And these are the two different provisions that you have on that slide. If it's similar, yeah. His question was whether or not if you had a prior aggravated battery that was DUI, you could score it as like this. And I think that's probably, I don't know why it wouldn't be. Mm-hmm. Right, and you would, since it is a person now, that would maybe change that. This may be of interest to you as well. There were quite a bit of testimony about this in terms of statute of limitations for these sex crimes. Part of the issue was, or one of the instances, uncle confesses on tape that he raped niece can't do anything about it. Statute of limitations is run. There is no statute of limitations now for rape or ag criminal sodomy. And they also, sexually violent crimes commence within 10 years when the victim is 18 years or older. And the other one, actually, most of the statute itself, or limitations, kind of hinges on where the age of the individual is. And 18 is kind of the cutoff point as to when you can actually, and you can kind of read through that. Legislature really liked their firearms last year. And this is actually something that's different than what we have now. Anything above a felony is, or anything above $1,000 is a felony. Not anymore. If you steal somebody's firearm, it doesn't matter how much it costs, it's now a felony. So part of the push on this was mainly individuals breaking into pawn shops, gathering all the guns up, and then distributing them to the criminal enterprise and their network. And so from that came HB 2278, and now if you have a firearm theft, it's felony. And the burglary is interesting as well. If you commit a burglary with the intent to commit a theft of a firearm, it's a level 5 now. It started out as actually being a person felony, but they amended it to a non-person. So it's a level 5 non-person. And the last thing I have is, if you were ever wondering about your synthetic cannabinoids, UR 144 is now illegal. It was marketed on the internet and still is as incense, potpourri, bath salts, like some of the other synthetics. This has the same, does the same thing to you as THC does. It mimics that. DEA, I think it was back in March or May, outlawed it as well, but it's been actually put on the Schedule I controlled substances, which means it's illegal. It's highly, I'm trying to remember, it's highly abusable, and it doesn't have any medicinal value. So